Very good evening. Thank you, Vinita ma'am, Honorable Vice Chancellor sir, respected Registrar sir, dear faculty member and dear student. First of all, I am thankful to the Honorable Vice Chancellor sir for giving me an opportunity for this presentation. And the topic of my presentation is demystifying the code on wages 2019. Vinita ma'am, shall I share my slides?
Yes,
Pravesh,
yes,
please share your. Yes.
Right. Is it visible?
yes, ma'am.
Pravesh,
It is visible.
It's
yeah,
visible.
thank you so much. So, why I have chosen this topic, as you know, the Code on Wages was enacted in 2019, and the draft rule also were enacted. But there are certain gray areas after rules and the code. Certain gray areas are there. So, I think that the government would clarify. I will discuss those areas with you when I was discussing the provisions of the Code on Wages. So I'm not going to historical background and the Supreme Court cases. What I am doing in my presentation, I will be discussing I will comparing the legislation which were prevailing earlier and the Code on Wages. Now, the agenda of my presentation would be what is the background of this Code on Wages and importance of a wage policy, outcome of the wage policy in India, and assessment of wage policy in India prior to the code, and brief timeline of the code, amalgamation, and features of the code, and the conclusion. Now, if you see, first, as you know, the Ministry of Labor and Employment by way of notification dated December 18, 2020 has notified and brought into immediate effect certain provisions of the Code on Wages 2019. So basically, it was the advisory board for the central government, which empowered to advise on matters relating to fixing the minimum wages. Now, why there is a need of an importance of a wage policy? If you see the importance of wage policy, why we need a wage policy, the basic aim of wage policy is that it's overcome poverty and reduces inequality when we have the strong wage policy in our country. Then it protects workers from an unduly low wage and overcome gender inequality. As you know, the purpose of the minimum wages, most of the labor legislation which we are having, that is a pro-labor. So why we have a labor laws? The purpose of labor law is to stop the exploitation of the worker. So importance of a wage policy, the three importance which I said to you are mentioned in the slide. That is the aim of the wage policy. So we have three ILO convention, as you know, apart from the Indian Constitution. The ILO Convention, India is the founding member of a International Labour Organization. There are three important ILO convention on a wage policy. First is a Protection of Wage Convention 1949, then Minimum Wage Convention and the Protection Workers Claim. So these are the three ILO convention on wage protection on minimum wages. But unfortunately, India has not ratified any of the convention. And India doesn't have, though we are underdeveloped country or developing country now, we can say, but we don't have any structured wage policy as yet. So there are ad hoc policy which are prevailing, but we don't have because we have not ratified any of the ILO convention on wage policy. Now, next is what was the need of this wage policy? Now, if you see the code on wages, why we need a code on wages, why there was a need of our codes. Now, if you see the labor laws, India inherited the labor laws from the British rule, and many of the, if you see, the making changes in the labor laws were very slow till liberalization touched India's boundaries in 1991. It was the second National Labour Commission on Labour, which was set up in 1990, suggested rationalization of existing labour laws. The National Commission of Labour submitted its reports in 2002 and recommended the following labour laws should be into the following groups. First should be industrial relation, and second, there should be a code on wages and social security and occupational safety, health and working condition. So it was the recommendation of the second Labor Law Commission, and based on that recommendation that India has enacted the codes. Now, what was the need of this code on wages? If you'll see, so as we know that there were four legislations which were amalgamated under the Code on Wages 2019. So if you see that the code provisions of the laws which were there, the most complex minimum wage system in India, in the world. So we were having, because there were three wages or wage legislation which used to regulate the wages in India: Payment of Wages Act, Minimum Wages Act, and then this Payment of Bonus Act. So these were the three legislation which used to regulate the wages in India. So too many wage rates. Now, when we talk about the minimum wages or minimum wages 1948, prior to the Code on Wages 2019, so the purpose of minimum wages was to fix the minimum wages for a scheduled employment. Not for every employment, there was a schedule only for those scheduled employment. And who will decide the scheduled employment? It was the appropriate government, in case a state or the central government, right? So they used to fix the minimum wages for the scheduled employment. So 429 scheduled employments were there under the schedule. Then 1,915 scheduled job categories were there. Limited coverage. It was not that minimum wages we were having that all the workers were, prior to this code on wages, that all workers were covered by the minimum wages or the wages act which we were having, laws we were having. So only the 60% agriculture worker were excluded from the coverage of the wage regulation which we had. Then the unorganized workers were not were excluded from the wage code, which wage legislations which we were having. So what I am trying to explain, that it is not that wage regulations were there, all the workers were covered by these minimum wages or the Payment of Wages Act or the Payment of Bonus. Only 66% of workforce were covered by these laws. Then low wages and wide variation in rates within and across provinces. So 37 wage authorities were there under these three legislations. So the fixing of wage, though there was a provision under the minimum wages, that minimum wages would be fixed and it would be revised within 5 years. That provision, that law was there under the minimum wages. In spite of that, wage fixed was arbitrary and not updated at a regular intervals. Then lack of technical capacity and non-functioning of institutional machinery, undue low wages, median wages being rupees 267 per day in 2018-19. So then there was a minimum rate wages in some province set lower to poverty line standard of living. So minimum wages, that one of the reason of a migration was the minimum wages, because Delhi was having a higher minimum wage and the Assam was having a low minimum wages, or Bihar or UP or Odisha, these states were having the less minimum wages as compared to the developed states. So the persons who were residing in these states, they used to migrate because of this minimum wage. So that is what I'm trying to explain. The minimum wage rates in some provinces set lower to poverty line standard of living. That was one of the reasons of a migration. Then 20% regular and 42% casual workers received wages less than national floor. Now, what is the national floor? National floor is a wage which would be fixed by the appropriate government. And who would be the appropriate government? It would be the state who would be appropriate government. And it is clearly stated under the Code on Wages 2019, when the central will fix the minimum wages, so floor wage, so the floor wage of the state should be higher than the wage which is fixed by the central government. But we have seen prior to this code on wage 2019, so many states were having the less than the national floor. Their minimum wages were less than the national floor. So these were the few reasons to enact the Code on Wages 2019, and then multiplicity of authorities, lack of uniform definitions, high compliances requirement, enhances cost of doing business in India. These were the reason for enacting the Code on Wages and making the necessary changes in the existing wage regulations or legislation. Now, after this, then I have just discussed in this slide. I draw your attention to this slide. I have just discussed the review of some what was the situation of a minimum wage in India. So you can see I have referred to the International Labour Organization India Wage Report 2018, in which it is clearly stated that inconceivable to think that India's economic growth in the last decade has not reached the most vulnerable, with low pay remaining pervasive and wage inequality is still very high. Then I refer to the other review, that is, the Indian minimum wage policy does not raise wages, but not at or near the bottom of the wage distribution as would be expected of a wage floor. Its strongest effect is just below or even above the median wage. Then minimum wage in India does not operate as a conventional floor wage to protect the lowest paid worker. And last is, I refer to the journal of Bhattacharya, in which it was clearly mentioned there has been a sharp decrease in the share of wages in value added since the 1980s as wage lagged behind increase in labor productivity. So these are the few reviews which show that India's, as I discussed with you, we were not having the structured wage policy in India. Now, in furtherance of the recommendation, as I've discussed with you, it was the second Labour Commission which recommended for the code on different codes on labor laws. So in furtherance to recommendation of the second National Commission of Labor, the Ministry of Labor and Employment Ministry held consultation with the different stakeholders, trade unions, employer, and state government. And the code on wages, the first time the code on wages wage was introduced in the year 2017, and because of the dissolution of the 16th Lok Sabha, it couldn't pass. Then it was again introduced in the year 2019, and Lok Sabha on 23rd July 2019, and passed by Lok Sabha on 13th July 2019. Then passed by the Rajya Sabha on 2nd August 2019, and assent of the President on 8th August 2019. As I discussed earlier, it was not that all the provisions of the Code on Wages 2019 was notified. Only the limited provisions were notified by the government. Then, as I've discussed earlier, that there were four legislation, particularly three legislations were there in India, which used to regulate the wages in India: the Minimum Wages Act, Payment of Wages Act, the Payment of Bonus Act. So these legislation and this Code on Wages 2019 subsumes the following four laws. First is the Payment of Wages Act, which is of 1936, to ensure payment of wages to employees are disbursed on time and no undue deductions are made. So under this Payment of Wages Act, there is a provision that when the employer will deduct, that deduction should be authorized deduction. So this was the one act which used to regulate the deduction and payment of wages. What would be the period of a payment of wage? And this is now, this particular payment of wage is now the part of the Code on Wages. Then Minimum Wages Act 1948, as all earlier discussed, the purpose of Minimum Wages Act was to fix the minimum wages, fix and revise the minimum wages for the sweated employees, for the scheduled employment. So there was a schedule, the list of the employments were there, and on the basis of that scheduled employment, the minimum wages were fixed. So now this Minimum Wages Act of 1948 is the part of the Code on Wages 2019. Then Payment of Bonus Act 1965. As you know, prior to 1965, in India, there was no legislation which used to regulate the bonus. So this was the first act which used to regulate the payment of a bonus. It was enacted in the year 1965. Now, this particular act is also the part of the Code on Wages, and the purpose of this particular act was to provide for payment of a bonus to person employed in certain establishment on the basis of profit or production of a productivity. And then last was the Equal Remuneration Act 1976. The purpose of Equal Remuneration Act was to mandate equal remuneration and to prevent gender discrimination in employment matters. Now, these four legislations are the part of the Code on Wages 2019. So there are different chapters, and these acts are incorporated under the different chapters under the Code on Wages 2019. Now the next is the applicability of the Code on Wage 2019. So I have explained that there were four legislation which used to regulate the wage in India. So if you see the applicability of these four legislation, first I will just explain you the applicability of the four legislation, and then I will come to the applicability of the Code on Wages 2019. When we talk about the Payment of Wages Act, so it is clearly stated prior in our Payment of Wages Act that it will be applicable to the only 8 industries. Only 8 industry, and apart from that industry applies to those employees whose wage were 24,000 per month. So there was a wage ceiling. Those who were drawing 24,000 rupees, the Payment of Bonus Act would apply to them. And also only 8 different categories of industry. It could be a mines, it could be a manufacturing or oil food. The Payment of Wages Act would apply on that. Then there was another act which was a Payment of a Bonus Act. It applies to all types of industry across the nation. So Payment of bonuses, it will be applicable to all the industry, not specific industry, not particular industry. So applies to all the industry across the nation. It was a central act and has central rules. It also covers all those persons who is earning up to 21,000 per month. So those employees who were earning up to 21,000 per month, they would be covered under the Payment of Bonus Act. They can claim the bonus from the employer, and then they become eligible to get statutory bonus under the Payment of Bonus Act. Then the third legislation was the Minimum Wages Act 1948. So where Minimum Wages Act would apply, the Minimum Wages Act would apply only to the scheduled employment. So there was a schedule under the Minimum Wages Act, and the list of the employments were mentioned, and the Minimum Wages Act would apply only to those scheduled employment, not any other employment. So then the power was given to the appropriate government. Appropriate government could be a state government, it could be a central government. They can incorporate the other employment under the schedule, but basically it will be applicable to scheduled employment. When it comes to equal remuneration, it was applicable to every industry. So so 4 different legislation. If you see the applicability of 4 legislation, it were different. Now, under the Code on Wage 2019, it simply says the code is applicable to all employees employed in both the organized and the unorganized sector. So nowhere it is mentioned it will applicable only to the certain establishment, only to the 8 industries, only to the scheduled employment. Simply that is the major difference between Code on Wages 2019 and the earlier legislations which we were having. So when it comes to the applicability of Code on Wage 2019, it will applicable to all employees employed in both the organized and the unorganized sector. Now, here I just wanted to clarify one thing. When it comes to the organized sector, it is not nowhere mentioned under the Code on Wages 2019. But then there is a section 15, subsection 4 of the Code on Wage 2019, where it is mentioned, it is defined domestic worker. So when it is discussing domestic worker, it means it is covering the unorganized sector. So when we go through the definition, we won't find the unorganized sector or the unorganized workers definition. That is given under the Code on Social Security. But under the Code on Wages, we don't find. But as I've said, section 50, subsection 4 is there, where the domestic worker is mentioned. So domestic worker is entitled to get the wages, bonus, and payment of wages. So all chapters will apply on that. So that is the one reason I said it will applicable to organized and unorganized both the section. Now, next important, this Code on Wages, there are 3 definitions which are very, very important. The 3 definitions are employer, worker, employee, and employer, worker, and employee. Now, there are 3 legislation which defines these 3 terms. It is a Minimum Wages Act, Payment of Wages Act, and Payment of Bonus Act. These 3 legislation defines who will be the employer, who will be the worker, and who will be the employee. Now, first, I will just give the explain the definition of employer. I have not mentioned here, but the definition of employer, if you'll see, under the 4 legislation which we have I was discussing. So under the 4 legislation, somewhere under the employer, they have mentioned the owner would be considered as an employer, like a factories act. Somewhere they said the legal representative would be considered as a owner of a factory or owner of a establishment. And somewhere they have excluded the definition of excluded owner from the definition of an employer, legal representative from the definition of a owner of the employer. Now, this led to a lot of confusion, leading to uncertain implication, ambiguous interpretation, and doubtful applicability. So the Code on Wage 2019 is unifying many such terms which are common to various laws by giving them common definition. Now, if you'll see the definition of employer now under the Code on Wage 2019, the first time they have included contractor as an employer. Earlier, contractor was not employer, though the contract labor is not part of the discussion of the Code on Wages 2019. But they said that contractor would be considered as an employer under the Code on Wages. So the thing is, now contractor would be responsible for giving the minimum wage. Contractor would be responsible for giving the payment of bonus. So contractor first time they have included as an owner. Now the owner under the Code on Wages 2019, the owner is excluded from the definition of an employer because of a vicarious liability in case of a factory. Now the occupier and manager would be considered as the employer. But owner of the factory, they have excluded the owner of the factory because of the vicarious liability. So contractors included, owner is excluded from the definition of a employer. But then when we see the payment of bonus, in payment of bonus earlier, not under the Code on Wages 2019, payment of bonus, owner was included under the definition of a owner, but here employer. But under the Code on Wages, he is not included. So even if for payment of wages, we have to see the definition of employer, the owner won't be considered as a employer. But prior to Code on Wages 2019, owner was the employer under the Payment of Wages Act. So this is the one major change which brought in by this Code on Wages brought, that contractor would be considered as a owner. Then after this, then employer and employee. Now, when we see the definition of employee and worker, so who would be considered as an employee and who would be considered as a worker. Because suppose if I don't come under the definition of worker or employee, I cannot claim a minimum wages from my employer. I cannot claim a payment of bonus from my employer. So it is noted here. I don't know. I have that is what I started when I introduced the code on wages. I have there are certain gray areas which the government has to clarify, because under industrial relation, they said the apprentice would be considered as a worker. But under code on wages, under the definition of worker and employee, they have excluded the apprentice from the definition of employee and a worker. So he won't be considered as a worker or employee under the code on wages 2019. But under the industrial relation code 2020, apprentice would be considered as a worker. Now, when we see the definition of employee, so why there are two definitions, employee and worker. Now for code on wages, now take an example, administrative staff or the managerial, they would be considered as an employee. So employees would be under the definition of worker. Only those who are involved in manual, unskilled, skilled, technical, operational, clerical, or supervisory work. And if a person is involved in a supervisory work and he's drawing 15,000 rupees, more than 15,000 rupees, he would be excluded from the definition of a worker. So minimum wages would be, for in context of minimum wages, this definition is very important, because when we go through the chapter on minimum wages, the employee cannot ask for a minimum wage. It is the worker who will ask for the minimum wage. So under the definition of worker, they have excluded the persons who are involved in managerial capacity, who are managers, who are working, who are involved in administrative capacity, and who are doing the supervisory work and drawing 15,000 rupees. They won't be considered under a definition of employee. So first time they said, now it is stated under the definition of employee that those who are involved in administrative work, managerial work, or supervisory work, they would be considered as an employee under code on wages. Now, why this is there? Because now this code on wages, the definition of wages will be applicable in case of a gratuity also, in case of a payment provident fund also. So the persons who are managers or who are administrative, they would be considered as an employee under the code on wages, and the definition of wages would apply on them. And for that code also, the same definition, this definition will be borrowed from code on wages for a code on social security. Then there is another important definition which is very, very important. That is a definition of a wages. Now, definition of wages is very, very important. Whenever we go through the definition of wages, what we see, because as I've said, industrial relation, 3 legislations were there. Then 4 legislations were there. Under social security, we have many legislation. Under every legislation, there were a definition of a wages. Only there was an Equal Remuneration Act where the remuneration word is defined, not the wages. But under these 3 legislations, wages are defined. So now, when we go through the definition of wages, it is important to know what would be included under the definition of wages and what would be excluded from the definition of wages. Now, I'll compare this definition with the definition of the previous legislation, and then I'll come to the definition of wages under a code on wages 2019. Now, when we see the definition of wages under the Minimum Wages Act 1948, it says all remuneration. HRA is included, house rent allowances is included under the definition of wages under the minimum wages. But then there were certain things which were excluded under the definition of wages under the minimum wages. That is, that traveling allowances won't be considered as a wages under minimum wages. Then house accommodation won't be considered as a wages under a minimum wages act. Then contribution to provident fund and pension and gratuity won't be considered as a wages under the Minimum Wages Act 1948. Then there was another definition of wages which was given, which was defined under the payment of a bonus. So in that case, under the payment of bonus, all remuneration would be considered as a wages. But if there is a retrenchment compensation which was given to the worker, that won't be considered as a wages under a payment of a bonus. Then gratuity bonus contribution to fund excluded under the definition of a wages under the payment of a bonus. Then there was a last legislation which was a payment of wages, all remuneration. Bonus would be excluded from the definition of a wages under the payment of wages. So why I have discussed this, you can see the definition of wages under all the three legislation. What would be included, what would be excluded, and the equal remuneration, as I discussed with you, under equal remuneration, the definition of wages is not there, remuneration is there. Now, the problem is that what would be considered as a wages and what would be excluded from the definition of wages. Now, to bring the uniformity in the definition of wages, the new definition of wages is given under the Code on Wages 2019.
Ma'am,
Now,
it's been 30 minutes.
Yeah, just I'll try to conclude it. So under the wages, basic wage, clearance allowances and retaining allowances would be considered as the part of the wages. What won't be considered as a wages? That is a bonus, provident fund contribution, conveyance allowance, house rent allowance, overtime allowances, any commission, gratuity, retrenchment compensation will be excluded from the definition of wages in context with the Code on Wages 2019. So this definition will apply to a gratuity. This definition will apply to a provident fund also. Now, but then there is a problem. Then when you calculate the wages under the equal remuneration, so conveyance allowance would be included under the definition of wages when you calculate the wages under the equal remuneration. So there is a, we can say gray area. It is not, there is no clarity to what would be considered as a wages. And then there is a other thing which is mentioned under the Code on Wage 2019. It says, if the exclusion, the second, which won't be included under the definition of wage. So it says if the inclusion herein exceeded above 50% or prescribed by the government limit, then the amount which exceeds shall be added to the wages. So 50% or anything which is prescribed by the central government, if that would increase the 50% wages, then that would be considered as the wages. So it is not very clear what would be considered as a wages under the Code on Wages, though the definition is given. So, but again, it is the clarity. There is a more, we need more clarity when it comes to the Code on Wages 2019. Now, then floor wage, as I discussed with you, it is the appropriate government. So appropriate government is defined under the Code on Wage 2019. The floor wage would be fixed by the central government. And this floor wage, when fixed, so few things incorporated under the Code on Wages which was not there. When the floor wage was fixed by the appropriate government, that the central government, it will set based on geographical areas. So maybe the floor wage would be different for the different states. Then the rates of wages as may be prescribed by the state government shall not be less than the rate of floor, as I discussed with you. So central government, if it is fixing 178 rupees as a floor wage, then if the state of Chhattisgarh is fixing the minimum wage, so this minimum wage should be upper than the floor wage. It should not be less than the floor wage. That is what the meaning of this floor wage is. Then deduction. So as a deduction, payment of wages payment of wages talks about the deduction. So if there is an unauthorized deduction, that will be that employee can claim. So this is about the deduction. Then prohibition of discrimination on ground of a gender. So under the Code on Wages 2019, prior section 3 of the Equal Remuneration Act talks about men and women. So now under the Code on Wages 2019, they have included this gender word, and also there is a bill, 2019 bill. Now the transgender would also be included under the Code on Wages 2019. Then equal remuneration, payment of bonus. Earlier, the applicability, as I discussed when we were discussing the applicability of the payment of bonus. So the employee is drawing wages not exceeding 21,000 per month. Now it depends upon the government. They will prescribe the wage ceiling, and on the basis of wage ceiling, that would be fixed, and the employee can claim the minimum wages. Then there is an inspector cum facilitator. Now this new word is incorporated. Facilitator, that was not there earlier. Inspector was there, and the other authorities were there under the different legislation, but now it was under the Code on Wages 2019. For compliance, they have mentioned inspector cum facilitator. Now this is very, very important, which has this fines are enhanced under the Code on Wage 2019. Now less payment as defined in Code on Wage 2019. Now if the employer is giving less wages to the employee who are employed by him, then for first offense, the fine would be 15,000 rupees, and repetitive offense within 5 years may lead to imprisonment up to 3 months, and fine may extend up to 1 lakh rupees or both, and contravenes with any other provision. If the employer contravenes any other provision of the Code on Wage 2019, in that case, the fine up to 20,000 rupees, and repetitive offenses within 5 years may lead to imprisonment up to 1 month, and fine may extend up to 40,000 rupees or both. Then non-maintenance of improper maintenance of a document. So it is very necessary. If you are having an unorganized worker in your establishment, you should have a proper register for them. They should sign and everything. Now, suppose take an example, if employer is not compliance with these non-maintenance of improper maintenance of a document, in that case, fine up to 10,000 rupees. Then conclusion, the code is well intentioned piece of legislation which aims to balance the interest of the employer and the employee worker. Though the code contains substantial portions of the repealed legislation, it makes a decent attempt to replace their absolute provisions. The provision of the code inspire confidence in the business community, and further clarity can be realized once the subordinate legislation and rules under the code are in place. So thank you.
Thank you so much, ma'am, for such an informative presentation. Now the session is open for the question. If any participants have any question, doubt, queries, they are requested to type in chat box. The first question, which has come from Dr. Paparao sir, is asking, Madam, as I understand that the rules under Wage Code 2019 provides for national floor wages. Is there any clarification regarding how this floor wage is different from minimum wage? Can minimum wage be less than the floor wage? If so, what are the consequences? Throw some light. Question from Papa.
Right. So as I've discussed with you, that floor wage would be fixed by the appropriate government, that is the central government. So minimum wages would be fixed by the state government. So always it is the like a rule that the state will fix the floor wage. Suppose right now the floor wage is 178 rupees, right? So when the state is fixing the minimum wage, suppose take an example for Chhattisgarh will fixing the minimum wage, that minimum wage should be upper than the floor wage. So there is a difference between the floor wage and the minimum wage. Minimum wage would be fixed by the state government, and the floor wage would be fixed by the central government. Yes.
Ma'am, second question is asked from Dr. Pravesh Kumar Rajput sir. He's asking, the claim that the provisions in the codes are for the welfare of unorganized sector workers, including gig economic workers, is half-truth as a huge swath of the workforce, which includes migrant workers, home-based workers, and self-employed workers, has been left out. Can you please put some more lights on this issue?
Sir, first of all, when I was discussing the applicability of the Code on Wage 2019, I compared the applicability of Code on Wage 2019 with the existing repealed legislation. So it was clearly stated that the Code on Wage 2019 will apply to all the industries, right? Unorganized, irrespective of their sector, whether it is an unorganized or organized sector. So as far as you are discussing about the gig workers, that would be covered under the code on social security. But when it comes to the minimum wages, as I've said earlier, the minimum wages for only for the scheduled employment, but now the minimum wages for all the industry, all the workers who are employed. Even section 15 subsection 4 says if you're employing more than 5% in your household, you are entitled to give them minimum wages, payment of bonus, and all the claims which are under the code on wages 2019.
Is there anyone who is having any question, doubt, query, whatever? So this was the last question from Pravesh sir. Is there anyone having any query, doubt, question? So no questions yet. Thank you so much, ma'am, for your presentation. Now I request Honorable Vice Chancellor sir to give his concluding remark on today's presentation. Over to you, sir.
Thank you. I think, I would call it, this is part two compared to what we had at Exarca, which Dr. Balwinder herself was the discussant sometime few days back with Nega Koshi discussing about the wage policy, but especially from a perspective of women as workforce. And this one takes a generic look about the wage policy, etc. I'm pretty sure that this exposition today, Dr. Deepak Srivastava would have benefited a lot, as we are moving towards new contracts of, various thing for the upcoming year. So as I said that it's I would say from a macro perspective, interestingly, a lot of things were fought from American context, which many people, if you ask a lot of non-lawyers or even some lawyers, where is the origin of May Day celebration? I find many of them will tell Soviet Union. But actually May Day celebration starts from United States. Aggressive unions, rather militant unions, are part of the United States labor history, which was in a sense professionally organized shop floor level, and then they were quite a powerful thing in the 30s and 40s. But over a period, what is happening is United States is no more identified with labor reform, the sense, the nature of labor. When you say, by and large, the focus has been on blue collar, what you call, and there is a white collar, which labor, what you call, and quite often, even in white collar, it's often done on management and above. But as now, there is people who work like blue collar, but they are into what you call service industry. So the number of percentage of service industry in this world in different parts are tremendously increased, moving labor force a big section of emerging opportunities, which has a different dynamics altogether. And even the white collar became one of the important identifying force in the world today is IT, information technology. So in fact, even though there is no legal ban of not to have a trade union, you find IT sector doesn't have for various reasons. One is that probably it's still a good time, so they don't really feel the pinch compared to shop floor. Or second is that it's a little footloose job in a way. People keep moving here and there. So there is nothing like a loyalty of a lifetime to a workplace. So often that doesn't allow them to get into certain level of solidarity. And probably the high tag of IT makes them so individualistic to be collectively joining. So even though there were a lot of discussions which happened that will there be a union or is it being discouraged, all that. But the profile is keeping changing. And in fact, another factor is what you call as contract labor, which universities like us are also encouraging at a point of doing that. But that is entirely different in the sense, not taking responsibility per se, but rather leaving it to certain professional outcomes and professional responsibility without compromising on what could be the wages, etc., what is happening. So this is one. And again, put all this together, white collar, blue collar, service industry, manufacturing, still you will find the whole labor force in the country as such, it's still a very small percentage, which law theoretically is trying to touch and many times unsuccessfully is trying to implement things. So it is probably again a lot to do, in my opinion, with the new contours of free market, which has emerged and emerging. And we don't know what post-pandemic overall, wealth and other things could be. So in that context, it is certainly what you call as for those who are part of the labor law, what I call as movements or labor law studies or labor law researchers. I see many of my friends who are lawyers who have a great depression, who often say that when the earlier few decades back, when judiciary was more quote unquote pro labor in certain gray areas, they find it that is not so romantic about pro labor or fend off yourself or what they call it as like we don't have any great duty towards a complex marketplace. That's what they say. So that many people worry for laborers to even to get lawyers. Earlier you had some real maverick lawyers who were defending and who took their cases. Even that particular tradition continues to some extent, but you really find that has dwindled. Sometimes I used to really think how labor law is perceived in national law schools. In the sense, of course, it's important as a small portfolio of practice, but as a point of progress, how labor law, I really don't know whether it is considered as a what I call as a subject which you have to also run and finish it, because probably what you call as the more excitement, I wouldn't call glamorous or I wouldn't call it as money worthy. There are a lot of interesting areas of technology, corporate law, many things rather than labor law. Could be that then are we also really sometimes losing potentially vibrant and dynamic young minds not moving in that direction? Very interestingly, my own brush with labor law to an extent is to what you call as attend some classes and be with Professor Babu Matthew in National Law School of India when he used to teach. And I sometimes used to ask him how you are really keeping the interest in rather a subject which is perceived dry. Right? That's a question I used to ask him. He used to laugh off, but of course he's a great communicator. So he was able to, get that interest going on. And I had some few friends who were in labor law. One was kind of mentor to me to get into law was Justice Chandru, who was in Chennai Court for quite some time and retired now, and is a very important voice in many public forums. And Chandru was a hardcore, Mr. Chandru or Justice Chandru was a very hardcore labor lawyer. And we used to, as young friends, or some of us used to hang around in his office opposite Madras High Court for the sheer excitement of going and sitting with him and how he really strategizes, labor law cases and how he manages to do that. It was a sense of idealism at that point of time where he used to, many who come don't have money or they have very, very less resource. A lawyer is not going to see great, checkbook being, opened up in labor law cases. So there was a very interesting factor. So these are my earlier brushes. Of course, I was little moved away to more on corporate law subjects. So it was an interesting and exciting talk today about labor law. And we need to wait and watch what will be the new roadmap, post-pandemic. Sometimes we talk about whether free market, does it have its own limits? And beyond that, what is it going to be the old schools of labor law or a new way of really looking at labor law? And also how to make it more inclusive of a vast proportion as I said, gender-wise or profession-wise, how it has to be incorporated, we have to wait and watch. So let me place my appreciation for today's presenter and today's discussion for maneuvering this session. And I hope the audience could have got a glimpse of an area which they may not be sometimes directly involved. Right? Thank you.
Thank you, sir. Thank you, Honorable VC, sir, for sharing with us your experience about labor law and allied issues. So on behalf of the digital team, HNLU, I extend my generous thanks to the presenter, Dr. Balwinder Kaur, discussant Mrs.Vinita Tripathi, faculty members and students for attending this webinar and making it successful. Now I take the permission of Honorable VC, sir, to close this event. Sir.
Yes, thank you.
Thank you.
Thank you, sir. Thank you.